The Supreme Court takes up 2 gun rights cases for the first time in history. Plus, Glock gets set to overhaul its handgun design. All this and more on the news update.
No, the devil's got no hold on me.
All right, ladies and gentlemen, welcome back to the news update. I'm contributing writer Jake Fogleman, joined as always by Reload founder Stephen Gutowski. The Reload.com, of course, is where you can head on over today to sign up for our free weekly newsletter. It'll keep you up to date on all things happening in the world of gun politics and policy. For us this week, the big news is clearly that we have another Second Amendment case out of the Supreme Court. So for the very first time in the court's entire history, we're going to get 2 Second Amendment cases in the same term. So pretty big news there. This one is the case U.S. v. Hamani, and it relates to the federal ban on users of unlawful controlled substances from possessing firearms. In this case, I guess technically it's about a marijuana user, but it's a case that actually at least contains allegations involving a whole lot more than that as well.
Yes, a lot more. And I'm filming from the farm today. We're outdoors here. The sun is a bit bright this morning, but so excuse the picture quality. Although the background is much nicer than my home office. So at least perhaps people watching on YouTube will get to enjoy the scenery a little more. But if there's any animal sounds or whatever, that's what's going on. My wedding is tomorrow. For those of you keeping up with my personal life. But one of the things we value here at the Reload is consistency. We want to bring you the latest stories every week. And so we try to work around everything going on in our lives to do that. So I am at the farm the morning before my wedding, and we're doing this news update and it's a big one, right? As you mentioned, the Supreme Court has now taken a Second Amendment case for the first time. They've never done this before, which is notable in and of itself. I mean, it's notable at this point, given how limited the Second Amendment jurisprudence is at the Supreme Court. It's notable anytime they take any Second Amendment claim. And now they've, for the first time, taken 2 in a row, which is, increasing the velocity of these cases, maybe putting them, as one of our experts that we spoke to described, Mark W. Smith. He's a host of Four Boxes Diner, big gun rights advocate, and he said, whatever you think of how these cases are going to come out, and we'll talk a little bit about what the different experts from different ideological perspectives think about this case in a moment. But however you think it's going to come out, they are. They're taking more cases, which is good in theory for gun rights activists, because the court has to this point been, pretty favorable to expanding the recognized protections of the Second Amendment. To be clear, like recognized protections. I know there will be plenty of people who say that obviously what the Supreme Court rules does not necessarily define what Second Amendment protections are, but that does define what they are practically in the court system. So the more cases, the better, I guess, is the theory there. And, the more it becomes commonplace for them to take Second Amendment cases, the better, even if these particular cases, these 2 that we're talking about, might actually not have a major impact on, they might not be landmark cases necessarily. They might have very limited impact on real world application of federal gun laws or state gun laws in the Hawaii case. But, on the very least, it says something that they've now taken 2. Maybe they're going to continue to expand on their Second Amendment jurisprudence from here on a more regular basis.
Yeah, I think that's certainly the big news. And it's something that it's funny enough that it's the way I see this is almost like gun rights advocates made a wish on a monkey paw, because for a long time they've been saying, we got to get the court to take more cases. The Second Amendment doesn't get treated the same way that other rights get. A given session may have multiple Fourth Amendment cases, may have multiple First Amendment cases. Never happened in the Second Amendment. When are they going to start treating it seriously? And they finally get more than one case in a term. And this most recent one anyway, Hamani, is not one that really they or even anybody seems to be thrilled that they're taking. It's kind of a bit of a head scratcher, I suppose. The drug user
Yeah.
gun ban is something that's come up in litigation, so it is an issue. It's not the first time it's come up around the court's radar, but it's just funny to see that this is the case that they chose to take, and the reactions, I think, speak to that.
Right, and the reason for that, I think the gun rights activists would like them to take a, pot smoker, weed user, marijuana. I always feel pretty square describing these things in news stories. Like,
Yeah.
Marijuana user, like that's obviously people don't talk like that in real life, but people who smoke pot, if that was the only thing going on with Hamani, and it is the core of it's the charge. He's charged with being a habitual user of marijuana because he literally told police cops that's what he smoked weed,
Yeah.
a lot. And they obviously, when they raided his house, they found a gun and I think it was like 60 grams of marijuana. So it was a lot of marijuana. And he admitted that he smoked regularly. I think he said every other day, is according to the brief. So that, they got him pretty down pat on the being a habitual marijuana user. And so that was maybe the easiest charge to make here. And that's what the core of this case. But the reason his house was raided in the first place is much more serious. He's been accused by DOJ, at least, and not charged, but accused of having terrorist connections, of working for the Iranian Revolutionary Guard Corps on some sort of fraud. There's not a lot of details exactly what they're accusing him of doing for that group, but they have a lot of allegations in this brief that make him look like a pretty bad guy. And so, that being the case, that DOJ shepherded up to the court to hear on the drug user prohibition, when there are a lot of other cases where it is much more straightforward. Just somebody was pulled over with some, blunts in their ashtray and a gun. I think that was Daniels. That's the literal, basic case of Daniels. That's upset some gun rights activists, and it's led in our discussions. I talked to half a dozen Second Amendment scholars from all over the political or ideological spectrum, and they all agreed, unlike in Wolford, the Hawaii case about the default swap for gun carry on publicly accessible private property, the experts in this case in Hamani, they all seem to agree that Hamani is probably going to lose this case at the court. And there's some structural reasons for that too, not just the facts of the case, but also DOJ is the one who asked this case to be taken up. Hamani didn't want the court to hear this case at all. So that's probably a bad sign for him. The lower court ruled in favor of Hamani, so that's also generally a bad sign. The court is oftentimes going to be overruling the lower courts when they take up a case. Not always, but it's another, structural sign. And so, but interestingly too, there's some gun rights activists upset about this. Not necessarily the groups, right? You're not hearing a lot of noise from the NRA or, Second Amendment Foundation or some of these other groups officially, but you're hearing some noise from gun rights activists. But interestingly, the same way with the gun control groups, though, right? Like they're not talking about it at all in a positive way necessarily. They're not saying anything. You had a whole piece on this. What's the deal?
Yeah, that's right. I wrote this up for Reload members, but yeah, I think that was pretty, because it's so relatively rare for the Supreme Court to take a Second Amendment case. You typically see reaction one way or another from groups that deal with this issue when they do, just because it matters. It makes a big deal. The few things that the court says has a serious impact on what these groups do going forward. And even with Hawaii, which, say what you will about the Hawaii case, but it's a relatively modest change in the law, but you still had groups react to the fact that they took this up, dealing with Hawaii's gun carry law. Like you said, when Hamani got granted, not a single formal gun rights group issued a statement, not a single gun control group issued a statement either. And I didn't even see any individual members of the gun control groups make any comments. And I think it sort of speaks to maybe the sensitive political realities of this case.
Yeah.
Marijuana is something that as a marijuana use, it's now legal in 24 states. Gun control groups, just as a general matter, tend to be on the progressive side of the political spectrum, even beyond just gun control matters. You've seen them talk about things like abortion and criminal justice reform, and so progressive politics and a political outlook tends to be more sympathetic to, decriminalizing marijuana, or, at least not threatening someone who uses marijuana with criminal penalties. And I think that puts those groups in a bit of an uncomfortable place as well, where they tend to be very skeptical of this conservative-leaning Supreme Court taking anything up that has to do with the Second Amendment. But when it comes to a law that, at least in theory, can throw a marijuana user in jail for 10 years just by the simple fact of owning a firearm, I think that puts them in an uncomfortable position too. And so it just goes to show that no one seems to be too thrilled with this particular case that the court decided to take up.
Yeah, and I mean, it is fascinating to watch, because, like we said, this is what I mean. If we count them, this is, I think, like the 8th or 9th Second Amendment case the court has ever taken in its history. And so,
and that's counting like per curiams and Miller and things that don't even really speak to the modern scope of the right too much.
Counts Miller, counts Satano, and it's just. This is why we started off talking about how much of a big deal it is, because it might not sound like it. Like, this guy, it's as applied, so it's only his. In theory, they could rule very narrowly in this case. They could say, well, we're not going to rule on all marijuana users, but this guy who uses weed and is accused of not only using it but dealing it, and cocaine and promethazine, I think was the other drug. Some hard drugs in there, both use and dealing. And then he has this whole terrorist, allegation hanging out there too, which is extremely serious enough too, where they were able to get a search warrant to search his house based on the terrorism connection allegations. So, and he admitted a bunch of incriminating stuff, and I think there was a bunch of stuff in his text message that also makes him. He's a bad defendant. I mean, you had pretty much everyone, all the experts we spoke to said this. David Kopel, who's a colleague, not that you don't work directly with him at the Independence Institute, but he works there as the research director. He's a pro-gun scholar. He thinks that this is another case like Rahimi, where you have a very unsympathetic defendant, probably the least sympathetic of these drug user defendants that we've covered going through the courts. Mark Smith admitted that, said the same thing, essentially, that he's not a good defendant for the gun rights cause here. Joseph Blackman from the South Texas College of Law, same thing. He argued that most gun rights activists don't favor drug addicts owning firearms. It's not something that is a major part of the activism space. Now, I think it is a little more when it comes to marijuana than obviously other drugs, certainly. But and then we talked to a number of people from Adam Winkler also thinks that it's going to be difficult probably for. And he's a UCLA professor who's been a critic of the current court's jurisprudence on this. Drew Stevenson as well, another South Texas College of Law professor who writes a lot about the Second Amendment too, and is highly critical of the individual right interpretation. Basically, all these guys come from very different points of view on what the Second Amendment means and the legal scholarship here, but they all agreed that Hamani has a very high bar to clear, and with the makeup of the current court, even with the 6-3 conservative majority, which tends to favor expanding the recognized limits of the Second Amendment, that Hamani probably has a bad shot at this. They were a lot more unsure, I think, about the Hawaii case. There's the arguments that, as we talked about on the previous episode, that property rights might conflict with gun rights to a certain degree, and the conservative court might, some of the justices might go the other way on the question of property rights, depending on how it's, depending on the details of it. And we'll have to, obviously, all these cases, both these cases, we don't know what the court is going to. Nobody knows. None of these guys have inside information. They're just experienced people who watch this court very closely, oftentimes influence the court directly with their writings. Many of these guys have been cited in Supreme Court briefs and on the Second Amendment. So, they're very well informed, but nobody knows. They don't have secret knowledge of what the discussions are inside of the court right now. We won't know more until they do oral arguments. And even oral arguments, as we've talked about plenty of times on the show, don't give you a perfect insight into what the court is going to do. It's just you're looking at the history and looking at these justices and how they've ruled in the past. That's where everybody's coming down. This is a pretty sure bet that Hamani is going to lose, even though he won technically at the fifth. There's also like a whole weird procedural aspect of this case, by the way. You know, at the Fifth Circuit, they didn't have an actual hearing on this case. They just deferred to a previous a precedent they'd already set on marijuana users in Connolly. And so you haven't really had this case directly litigated at the appeals court level. And so it'll be interesting to see what the court does with this. We don't have a ton of insight, but the vast majority of people think it's going to go against him, and at least as far as the experts we spoke with are concerned.
Yeah, and the procedural thing, just one thing to touch on there, because I think it speaks to, like we mentioned, why some of the gun rights people are a little annoyed, because it kind of speaks to the DOJ's maneuvering in this case. Is the precedent that this Hamani case was ruled on in the lower court, the reason it was able to be sort of short-circuited is because of that case, U.S. v. Connolly, which the DOJ never bothered to appeal. They just let that ruling stand. And that one was a much more straightforward marijuana guns case. And so they said that one where it literally blew a hole in the federal law and established a precedent, we don't need to touch that. But this one with a potential terrorist, we should send that to the front of the line, Supreme Court, and please hear that case. And so I think that speaks to what has annoyed gun rights advocates, not only because of, it sets up an unsympathetic plaintiff for this narrow issue specifically, but it also gets a Second Amendment case in front of the justices that isn't really, sort of to what Blackmun was saying, it's not really priority number one for the gun rights movement. They very much would rather see this time be devoted to an AR-15 case or a magazine case or a 18 to 20-year-old case or even another concealed carry case. And yet one of the very few, the justices only take something like 60 cases a year. And so any time that is not devoted to one of those cases is time that, at least in the eyes of gun rights groups, could be spent on one of the issues that they've been dying to hear the court address.
Yeah, and we talked about this when Rahimi came up, that Rahimi was also the result of some DOJ maneuvering. Now, that was the Biden DOJ at the time, and so it was pretty straightforward as to why the Biden DOJ might want to follow up Bruin with something like Rahimi, where they're on much safer ground to see federal law upheld, because Rahimi was not a good guy. He had a lot of serious allegations against him. And then, that's basically the exact same move, even though it's the Trump Department of Justice doing it this time, where, they're on much sturdier ground here because of the defendant in the case. And they intentionally, they literally told the court, hey, take this case and then don't take the other cases, with much more sympathetic defendants until after you've decided this one, and let this one guide your view on the drug user prohibition. And so if you're a gun rights advocate, it's pretty obvious why you might not be happy about that. Now this is the kind of person we're talking about here is somebody who listens to the Weekly Reload podcast, or is a gun rights lawyer, closely follows these things. It's your average gun owner, frankly, they probably don't even know about this, that this prohibition applies to marijuana users. There's probably, we talk about this being a relatively narrow case. I think everybody thinks, there's a real chance that they could come down very narrowly and just say, maybe there's some possible scenarios where the drug user prohibition is unconstitutional as applied to certain people, but not Hamani, because of all these, not just because he smokes weed every other day, but because he appears to, there's evidence that he deals drugs and that he also is connected to a designated foreign terrorist organization. They could easily go that route. But there are broader implications. There's likely millions of people who are violating this law every day in this country. Like you mentioned earlier, there's 24 states where marijuana use is no longer criminalized, at least. And so people might not, especially in those states, might not even understand that even if it's not a crime locally, it still makes you a prohibited person if you use marijuana regularly under this federal law. So, this case could come down and be very narrow and not really have much impact there. Although, yeah, the other thing about narrow rulings in both these cases, the Hawaii case and this Hamani case, is because there's so few Second Amendment cases, because the courts have the Supreme Court has handed down so few opinions on the Second Amendment. Anything they write is going to have an outsized impact at this point, until they have a lot more cases built up, right? Because any way that they interpret, even if it's just dicta, we talk about dicta a lot, right, on the show, and courts will cite dicta all the time. And so there's this idea that, yeah, dicta isn't binding, but it kind of is, right? In practice, technically it's not. And if a judge really feels strongly that dicta conflicts with the legal principle at play or whatever, then yeah, they might ignore it. But a lot of times they'll cite it as authoritative. And I mean, you know, we shouldn't dismiss dicta completely. Sometimes it's easy to do that and just be like, well, that's not the core holding here, so it doesn't matter at all. Well, that's not really true, right? So, you know, however they decide these cases, even, you know, whatever the core holding is, how they go about deciding it is going to matter a lot, because that'll give insight into how to decide future cases, even if they don't have anything to do with the drug user prohibition or gun carry restrictions. So, I don't know, you know, at the end of the day, these could both come down with very narrow rulings that have little direct impact on most people, and most gun owners' lives. But even in that scenario, there's likely to be a lasting impact that's not immediately obvious from the core holding, right? So these things all do really matter. And DOJ maneuvering to get a case to the Supreme Court that's unfavorable to gun rights activists, yeah, I mean, you can see why at least the people paying very close attention to this issue in the gun rights movement aren't going to be happy about that.
Yeah, especially if it creates a scenario like we've seen with Rahimi and Bruin, where it just leads to a raft of GVRs, grant, vacate, and remand, every other case that they want to hear, just so that courts can now, even if these are narrowly decided and they don't really change all that much, that still can delay litigation in other cases for years to come. So
yeah, that's exactly what happened in Rahimi, right? Rahimi's a fairly narrow holding, you know. Rahimi was a really bad guy with some serious credible allegations against him of violent behavior, some of the most despicable kind, right? Domestic violence. And, you know, that still has an impact on all kinds of cases. In fact, the Supreme Court seemed to want it to have a lot more impact than it maybe ended up having, because they kept GVRing stuff where it was like, not sure that
it was like concealed carry cases were getting GVR'd based on Rahimi.
But yeah, at the very least, it'll delay things, right?
Yeah.
You know, how many times have cases been GVR'd? How many times have a number of these big issues had to go through the rewash cycle because of like the Rahimi GVR? And yeah, now we have 2 more opportunities where they can do that again, and they don't have to take big cases, because technically, you know, the GVR hasn't come through yet. We haven't gotten back to, even if there's no real substantive change to the Bruin methodology or what. And that's another risk, right? Is that there's nothing that stops them from making a pretty significant change here. So we'll see what they do. But yeah, you could have a very narrow ruling in practice, but that has implications well beyond these 2 cases, though.
Yeah, certainly. And we'll stay on top of it once we find out, when we're going to hear oral arguments, and we'll cover all of that. And so just stay up to date here at the Reload. But outside of the Supreme Court this week, we also had another kind of fascinating story where earlier this week, rumors started percolating on social media that we were going to see a dramatic overhaul of Glock pistols, one of the most iconic civilian and law enforcement, frankly, handgun brands in the country, was just going to completely overhaul its inventory and release a new model. And, it started as just rumors with firearms retailers saying that they're hearing the same things from their supply chains, but no official comment from Glock. And then finally, an outlet, USA Carry, was evidently able to get a hold of someone officially from Glock to confirm that it is in fact true that a new Series V is going to be coming out that will be replacing most of its current offerings. And it sure seems like, this official source, I guess, didn't confirm, but it sure seems like this has to do with the big legal controversies over so-called Glock switches and all the lawsuits in progressive states and in legislation, in the case of California, an outright ban on Glocks.
Yeah, certainly the timing makes it seem that way. I think the Glock official statement that they put out doesn't confirm that necessarily. But I mean, it's hard to look at the timing and not see this being responsive, especially because they're not changing. Excuse me, they're not changing the external. They made a big point about how they're not changing the ergonomics or the externals of the gun, but they are changing the internals. And so we don't know yet what that's going to look like. We don't have the details of what these V models are going to look like, or what they're doing internally to change them. Especially since, there was already a claim that their latest generation, the Gen 5 Glocks, were more resistant to the Glock switch type modifications. So I don't know what they're doing in terms of that. How they're going to change the gun to be even more resistant, I guess, to the switch conversion. Which but I mean, they haven't even said that's what they're doing. They haven't said that we're changing the internals to make it more resistant to these sorts of Glock switch modifications. But I mean, it's hard not to read it in that context. And they haven't responded to any. We've asked them directly about this, of course, and they didn't respond. So that says something in and of itself, that they're not coming out and talking about it directly. They're not directly addressing the actual controversy. So that leads, obviously that leads a lot of people to assume that is what the change is about. And the wind is picked up here on the farm. Apologies for that. Also, my grandmother walked by a moment ago. So there might be some people in the background here. But yeah, so Glock, the California law is tailored to, everybody calls it a Glock ban, including us, because that's the practical effect of it. But it is tailored to target the internals of the Glock pistol, specifically the cruciform trigger bar or trigger assembly. I guess trigger bar in this case, whereas basically on most Glocks, they have a cross shape at the back of the trigger bar that interacts with the sear on the striker and makes the gun, operate semi-automatically, and that's what the Glock switch interferes with to produce, full automatic fire. So California, actually we haven't remarked on this, I guess, but it is somewhat in keeping with the more recent efforts by gun control activists to tailor laws to be more specific towards actual functioning of firearms, sometimes more competently than other times. But
Yeah.
but there is some sort of concerted effort to do this in the gun control movement after decades now of people, mocking or complaining about assault weapons bans being more or less based on ergonomic or cosmetic features, right? That's a huge talking point in gun rights spaces about how gun control activists have previously gone about these kinds of regulations, that they just don't know a lot about what they're trying to regulate, and they're more going based off of how things look than anything about how they function. And so this is first you had like what they did in Colorado, the updated, more modern version of the assault weapons ban, where they at least now this is what I mean, like sometimes more effectively than others, like because the gas operated, whatever they call it, this new version of the assault weapons ban is supposed to be about how assault weapon, assault weapon is obviously a statutory term, a political term, not really a technical term. But AR-15s and other firearms that they're trying to target, they tried to target them by going after what they were claiming to be their operating system, gas operated guns. But really the language of it doesn't actually do that. It's much it's not very well written. This law, on the other hand, this Glock ban in California is actually written competently in that it targets what it is about the Glock that they claim makes it more susceptible to conversion to full auto than other semi-automatics. Now, whether that's actually true or not is, I think an open debate. I think, personally, I'm not a gun designer, right? So I understand how these things function and how they work and how the bypass of the Glock switch works in practice, but whether it's easier to convert than other semi-automatic firearms. I know if you understand how semi-automatic firearm works, generally speaking, you can come up with some sort of conversion to make it fire in full auto, because semi-automatic is a harder mechanism design than full auto, because you're just it has to catch the sear without letting the trigger depress. So it's a harder thing to do. But anyway, the point being, I don't know if it's true that Glocks are more easy to convert to full auto, but they are at least going after the mechanism of how this switch works. They're going after the part that it interacts with, and saying you got to change this design. And so that's just something I haven't seen many people talk about, or we haven't discussed before. It's just like the Glock ban in California technically doesn't mention Glocks, but it goes after how Glocks, their internal parts, in a way that's actually correct, more so than some of the other attempts we've seen. But regardless, so Glock is changing this. We don't know if they're going to take out the cruciform trigger bar or not. We do know that Glock has a trigger that doesn't use a cruciform trigger bar. Most of their designs do, but they actually have like a performance trigger that doesn't use that design. So maybe they're just going to put the performance trigger in all these V versions of the Glocks to get around this pistol, these lawsuits and this California law. We don't know for sure. We'll have to see what they do. But I will say it's risky, I think, for Glock to do this. Like, yes, there's risk obviously in keeping the design, because it'll be banned for sale in California, which is a huge market that frankly already bans most of their newer models anyway.
Right.
That's why this becomes a total Glock ban, because the new models that are less susceptible to this modification are already banned under the Safe Handguns Act, because they don't have a magazine disconnect safety or a loaded chamber indicator, right? And so I don't know how they're going to get back on the roster. I guess there's the law allows them to make changes to their current models. So I guess these are going to be like Gen 3 Glocks that have an updated trigger mechanism in them. And that's another weird thing about it, because supposedly Glock is coming out with the Gen 6 relatively soon here. And so it's, why don't they just wait and do this change when they have their new guns come out? Well, maybe this is why, because the new gun's not going to be on the California roster, whereas perhaps the Gen 3 guns with a modification, technically not Gen 6 guns, so they can be on the I don't know. But I think it's risky, because yes, there's risk in not changing the design, because they're facing these lawsuits and this legislative action, which is probably going to spread to other states if it doesn't get struck down in the courts, which we'll obviously be covering that and watching that. But it's also risky to in the sense that it has the potential to really piss off their customer base. We've seen that happen before. If this is perceived as Glock giving in to pressure from California lawmakers or gun control activists to radically change we'll have to see if the new design is like substantially different in how it performs, because that'll obviously make people mad, especially if it performs worse. At the behest, the pressure from gun control groups. If they made a worse gun, people are going to be very mad about that, especially when they weren't technically absolutely forced to, right? Losing the California market is, I'm sure, bad for business, but I don't know that it's losing all of your customers in the rest of the country as a result of bowing to what California wants. Probably worse, right? And so it kind of comes down to how people end up perceiving this. And maybe it's too early to make an informed decision yet until we know more about Glock's decision making here. But I think that's the big risk, because you think back to, like, we've seen this before with some of the biggest gun companies. Smith & Wesson almost went bankrupt because in 2000 they agreed to a settlement with the Clinton administration that would have radically changed the kinds of guns that they could produce. And we've also seen, I think the founder of Ruger made comments supportive of the assault weapons ban, 30, 40 years ago, and magazine limits. And that was a similar huge backlash to that. Now, I will say the Smith & Wesson situation, the more recent one, there was an organized effort to push back against the company doing that, including by the NRA. And I haven't seen anything yet from the gun rights groups going after Glock over this. So, maybe they're waiting for more details, as I mentioned. But I don't know. There's certainly a lot of risk to doing it, I think, even if the guns are exact. I mean, I can also think of, like, Reming, or was it Colt, the Series 80 1911s, when they introduced this a new, an additional internal safety to the gun. I think that was more related to, like, liability fears about, single action trigger being, easier for people to negligently have negligent discharges. And so to make that less likely, they introduced a new internal safety, and so people, there's a lot of 1911, a lot of modern 1911s still have that Series 80 safety in them, but a lot of people were mad about that as well, even because they think that it changes the trigger pull a little bit, even if it's not a huge difference. So gun owners, and especially people that are buying guns most often, they care about these little changes to how their favorite pistols work, and the Glock is one of the most popular guns in the world. So if there's a significant change, and I also, even putting in that performance trigger, even if you think maybe it's a better trigger, it's a totally different kind of trigger pull, is my understanding. I've never shot one, but that's how it appears to be. And so even if you could argue it's better, a lighter trigger or something, people might still get upset because it's not the same. Sort of like New Coke,
right.
Technically in blind taste tests, people preferred New Coke, but when they actually put it out, everybody hated it, right? Because they wanted what it had.
I think that's a perfect analogy, because Glock, as most people know, their whole tagline is perfection, and they've been known for remarkable consistency. They release new generations that are basically the same thing as the old generation. That's kind of their brand is, hey, we have this very reliable basic handgun, and that's what our customers want. That's what our law enforcement contracts want. So we're just going to keep the same reliable thing. And if they're radically changing it, we don't know if they are or not yet. We haven't seen the Series 5 Vs, but if they are, that is the big risk there. That's for sure.
Yeah. So there's sort of double-sided risk to it. One, just changing a product that you haven't really made fundamental changes to since it was released, at least not, its internal functioning. Like I said, they do have a performance trigger that you can get, but it's not what most Glocks come with. That's a risk, just the product change itself. And then if your customer base perceives it as bowing to gun control activists, that's probably going to make a lot of them very mad as well. So there's definitely a dual risk to Glock doing this. It's a major thing. I mean, it's a huge thing. They're discontinuing almost all of their old models, except for the slimline. Their carry guns, is my understanding of it. And so that's a pretty huge thing. I mean, the Glock 19 it's like the Toyota Corolla or the Honda Civic of guns, and or the iPhone, right? The discontinuing that to make what sounds like is likely to be a significant change to how it operates. We'll see how that plays out.
We'll certainly stay on top of it, though, once we find out more. It's supposedly they're going to be hitting the shelves in December, so we'll find out here fairly quickly what these new pistols are like and what the fallout's going to be. So, getting into some of our newsletter links from outside the Reload this week, Kind of a fascinating investigation out of CBS Chicago, local reporting about a recent trend where, and this focuses on particularly African American gun owners. It's obviously a city with a high population of African Americans, Chicago, but getting pulled over in just basic traffic stops, routine traffic stops, and folks that have valid CCLs, so concealed carry licenses, or FOID cards, which Illinois law requires anyone who owns a gun in the state of Illinois to have a permit, essentially just to own a gun before you can even carry it. But folks being pulled over and producing their licenses, and then police running their licenses and not seeing them in their databases and slapping felonies on folks that have followed all the proper steps to comply with Illinois and Chicago's gun laws.
Yeah. Seems like a serious problem if that's the case, especially if it's disproportionately affecting Black people in Chicago. I mean, that's we have a lot of laws against that kind of discrimination. So, I mean, it could be another opportunity, I suppose, for the DOJ to step in, the Civil Rights Division, which has been criticized for backing off some of the race-related civil rights investigations, but has now, for really the first time in at least since Reconstruction, started to do some more Second Amendment investigations, denying Second Amendment rights. And so this opportunity for a crossover there potentially, but even if that doesn't happen, this needs to be fixed. It's not acceptable.
Yeah, we'll have to see if there's any sort of litigation. That the piece that they quotes Phil Smith from the National African American Gun Association, who we've had here on the Reload podcast in the past, and we've interviewed him for stories and stuff, saying that his group's getting involved in this issue. The Chicago Police Department didn't seem to really want to offer any comment as to what's going on, so they didn't give a ton of details. But that certainly, like you said, seems to be a real problem, and I think it also speaks to gun rights advocates anyway are so critical of permitting systems and all the like, because even if you go through all the steps and there can be flaws in that sort of a system, instead of just trusting that people don't have a record and can just carry their firearms. So.
Yeah, it's always been kind of an irony of the permitless carry movement, in that it's permitless carry is backed by the political demographic that is maybe more critical of DEI and other race-related initiatives, but the people most, I think, often obviously you've seen quite a lot of the people who back DEI type initiatives and are critical when DOJ doesn't do as much of the civil rights litigation as it used to. They tend to back the very strict permitting processes, but people who benefit, I think, most from this are just people who don't have the resources to go and get a permit, and in America, oftentimes people with race is a socioeconomic divider here. That's how it often plays out in the United States, and so disproportionately, I think permitless carry probably would help African Americans more in these sorts of scenarios. And certainly, we hear these kinds of stories fairly often from cities where you're seeing a disproportionate number of African Americans arrested for these sorts of offenses, or just carrying without a permit or whatever. And now, obviously, here it's even worse than that, because oftentimes these people in this story actually did have the required permits. But that, I think it just goes to show as well the nature of these permitting systems, even when they're not discriminatory in how they're applied. In the law, it's not written into the law that the race-based outcomes aren't written into the law, but they still can have that sort of disparate impact, just by the nature of how America is broken down by race and class and money. So, just certainly it's just another story that brings me back to that. We've seen it a number of times. We've seen it in Detroit with the rates of people being arrested for carrying without a permit. Even in a city that is majority Black, you still have a higher still disproportionately young black men who are being arrested for it, even with no other charges associated. And then we've seen it with stop and frisk as well, right? In both New York and DC. We've covered a lawsuit related to DC's stop and frisk policy. But yeah, so just sadly, not an uncommon story.
Yeah, for sure. And then the final link we want to bring to you folks is just an update on sort of the gun rights implications of the ongoing government shutdown. You wrote a piece, I believe, about a week ago for Reload members, talking about the fact that the ATF had basically taken away all of its examiners from its NFA processing division as well as its import licensing division. So that was obviously something that was affecting folks on the gun rights side. We have some reporting now that after we wrote that piece and then after some gun rights groups made some noise, that it sure sounds like the ATF decided to bring some examiners back to at least start approving NFA applications again.
Yeah, the National Shooting Sports Foundation, which is the industry's trade group, wrote a whole letter that was not a pretty unhappy letter to Attorney General Pam Bondi about this issue. And this kind of gets back to the schizophrenic nature of the Trump administration when it comes to gun activism. The top of this episode, we were talking about how DOJ maneuvered to get what is likely to be a very unfavorable case on the Second Amendment in front of the Supreme Court. And then at the same time, previously they had, during the shutdown, not prioritized the NFA processors or the import licensing processors at the ATF. But now they've been responsive to this complaint, and they're reopening, at least partially responsive, right? As far as we understand, and the ATF won't respond to any comments on this or the DOJ, so we can't know for sure, but we've heard from every gun rights group out there that they have reopened at least the NFA processing branch. We haven't heard anything about the imports, so that I presume remains an issue. We'll let you know if we get an update about that. But yeah, so like here they are being responsive to gun rights advocates' concerns at the same time that they're doing other things that make them mad. So it's I don't know, it's an interesting.
It is emblematic of the Trump administration's approach to like you said, to gun rights groups so far. So yes. Fascinating to see, and we'll keep you up to date on that because that is a major through line so far.
Absolutely. So do you have any fun plans this weekend, Jake?
I don't know about anything too fun. Just watching more football, I suppose. My Broncos are playing the Cowboys, and so that'll be a fun game.
I hope you win.
I'm sure you do. Yeah, I'm sure you, the Eagles fan, would like to see us beat the Cowboys. So.
I'd like to see that. Yes.
What about you? Do you have anything?
Barely beat the Giants in that wild.
Most insane
points in the fourth quarter.
Most insane football game I've ever seen in my life. For 3 quarters, we looked like the worst football team on earth, and I was ready to throw my TV out a window. And then all of a sudden, Bo Nix turned into prime John Elway, and we scored 33 points in the fourth quarter, and the most dramatic comeback in NFL history. So that was.
I appreciate that one too, because again, the Giants, I don't want them to win. So
yeah,
we're actually playing them this weekend, so I hope we don't need something like that to beat them, but we'll see. We weren't able to beat them at all last time, so hopefully that'll come out better this time. But yeah, it'll be interesting to see nobody knows who's good in the NFL, I think, at this point.
No, this year's insane. Yeah,
just a wild mix this year. No one's really pulling away, but yeah. What
about you? You got anything fun going on this weekend? Anything important going on?
Yeah, a little bit. We got the wedding tomorrow, so hopefully the weather holds out pretty well. The colors of the leaves are great here. It's a little chilly, late October wedding, but not too bad. I think it should be in the 60s, so it should be fun doing the whole farm wedding thing. We got a million things to do before the vows, but everything is working out fairly well so far, and I'm looking forward to it, and also just looking forward to be done with the whole, as I'm sure you recall, and now you are on the other side of it. The whole wedding planning thing is just
it's a lot. Yeah,
it's a lot. It's very stressful. So I'll be glad to be married on Saturday. Saturday night, I guess. we'll be officially married then, and then yeah, hopefully watch the Eagles win on Sunday. We'll see how that goes.
There you go.
All right. Well, that's all we've got. Speaking of which, I better get back to planning. I think my fiance and her maid of honor was walking around behind us a moment ago because they want to get everything finished. So I'm going to go and do that now. By the way, this week speaking of the Supreme Court, we have Alan Beck, who is the lawyer representing Wolford in that Wolford v. Lopez case at the Supreme Court about Hawaii's default swap law. So we are not missing any time here. We're going to have the podcast and the members newsletter as well. So look for those when they come to your inbox. But that's all we've got for you guys this week. We will see you again real soon.